The Madlanga Commission of Inquiry has turned a sharp light on how easily political power can bend the institutions meant to keep it in check. Yesterday's testimony from a senior National Prosecuting Authority official laid bare the mechanics of interference, instructions to drop cases, quiet phone calls from Luthuli House, and the quiet shuffling of dockets that never reach court. The witness did not name the president, but the pattern described matches the constitutional requirement that the NPA must act without fear, favor, or prejudice when that independence is compromised. The rule of law stops being a principle and becomes a slogan. Section 179 of the Constitution is clear. The prosecuting authority is independent and must exercise its functions without political interference. The testimony suggests this section has been treated as optional. If senior prosecutors can be leaned on to protect connected individuals, then the equality clause in Section 9 loses practical meaning. Citizens are not equal before the law when some dockets are marked untouchable. The Commission is not a court. Yet its record is creating a public ledger of how the separation of powers has been eroded in practice. The constitutional design assumes that Chapter 9 institutions and the judiciary will act as counterweights. What emerged yesterday was evidence that the counterweight can be neutralized by simple administrative control. Who gets appointed acting head? Whose security clearance is delayed? Which matters are referred to a task team that never reports? These are not dramatic coups. They are slow, bureaucratic moves that still produce the same result. Accountability evaporates. The rule of law depends on predictable enforcement. When enforcement becomes discretionary, predictability collapses. Opposition parties will argue this proves state capture never ended. That is too broad. The testimony points to targeted protection of a narrow circle rather than wholesale capture of every department. Still, the distinction does not help the Constitution. A single successful instance of political direction over prosecutions is enough to damage public confidence and to chill investigators who know their careers can be stalled without explanation. The Commission's legal team will have to decide whether to pursue a formal finding of constitutional breach or to limit itself to factual description. Either route carries weight. A finding would give future litigants ammunition in review applications. A factual record alone still supplies the raw material for parliamentary oversight that has so far been absent. The government's response so far has been procedural. It questions the Commission's terms of reference and hints that some testimony may be hearsay. That defense is constitutionally thin. The executive cannot both establish an inquiry and then complain when the inquiry examines the executive's own conduct. The principle of legality requires that public power be exercised within lawful bounds. It does not allow the executive to define those bounds after the fact. If the Commission's evidence is weak, the proper place to test it is in open proceedings, not in press statements. There is also the question of remedy. Even if the Commission finds clear interference, what follows? Past inquiries produced reports that gathered dust. The Constitution gives Parliament the power to hold the executive accountable. Yet the majority party has shown little appetite for using that power against its own leadership. Without a credible enforcement mechanism, the Commission risks becoming another expensive record of what went wrong rather than a turning point. The test will be whether Parliament eventually acts on its findings or whether the report is filed alongside others that documented similar problems. For the rule of law, the immediate damage is already done. Prosecutors who watched colleagues sidelined will think twice before pursuing sensitive matters. Judges who see dockets disappear will wonder whether their rulings can be nullified by administrative fiat. Citizens who once believed complaints would be investigated will lower their expectations. These are not abstract harms. They are the daily texture of a constitutional order that is losing its bite. The Commission still has weeks of hearings. Further witnesses may qualify or contradict what was said yesterday. That process must be allowed to run without political interruption. At the same time, the country cannot wait for another final report before deciding whether the current arrangements for protecting prosecutorial independence are adequate. The testimony already shows they are not. The constitutional question is no longer whether interference occurred, but what institutional changes are required to make it materially harder in future. Without those changes, the rule of law remains a statement of aspiration rather than an operating reality.